Family Code. Law on marriages. Trigger your mind. This is a collection of answers. I know you know the law. The purpose of this is to trigger your mind. Subscribe and comments below. Family Code. Emancipation. Nothing in this code shall be construed to derogate from the duty or responsibility of parents and guardians for children and wards below 21 years of age mentioned in the second and third paragraphs of Article 2180 of the Civil Code. Family Code. Retroactive application. Vested rights. Since the sale was executed in 1990, the Family Code is the law applicable. Under Article 124 of the Family Code, the sale of a conjugal property by a spouse without the consent of the other is void. Family home. Dwelling house. There can only be one family home, which is defined as the dwelling house where the husband and the wife and their family actually reside, and the land on which it is situated. Article 152 and 161, Family Code. Family. Constitutional mandates. Divorce. Section 2, Article 2 of the Constitution provides that the state recognizes the sanctity of family life and shall protect and strengthen the family as a basic autonomous social institution. It shall equally protect the life of the mother and the life of the unborn from conception. The natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the support of the government. Section I, Article 15, further provides that the state recognizes the Filipino family as the foundation of the nation. Accordingly, it shall strengthen its solidarity and actively promote its total development. The Constitution only meant to help the marriage endure, to strengthen its solidarity and actively promote its total development. Marriage. Annulment. Effects. Requisites before remarriage. Article 52 of the Family Code, namely, there must be a partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimes, which should be recorded in the appropriate civil registry and registries of property. The following are the requisites prescribed by law. 1. If either spouse contracted the marriage in bad faith, his or her share of the net profits of the community property or conjugal partnership property shall be forfeited in favor of the common children, or, if there are none, the children of the guilty spouse by a previous marriage, or, in default of children, the innocent spouse. 2. Donations by reason of marriage shall remain valid except that if the donee contracted the marriage in bad faith, such donations made to said donee are revoked by operation of law. 3. The spouse who contracted the subsequent marriage in bad faith shall be disqualified to inherit from the innocent spouse by testate and intestate succession. 4. If both spouses of the subsequent marriage acted in bad faith, all donations by reason of marriage and testamentary dispositions made by one in favor of the other are revoked by operation of law. 5. The judgment of annulment of the marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimes shall be recorded in the appropriate civil registry and registers of property. Articles 53, 52, 43, 44. Family Code. The children born from the union of H and W would be legitimate children if conceived or born before the decree of annulment of the marriage under Art. 45 of the Family Code has become final and executory. Art. 54, Family Code. The children of the first marriage shall be considered legitimate children if conceived or born before the judgment of annulment of the marriage of H and W has become final and executory. Children conceived or born of the subsequent marriage shall likewise be legitimate even if the marriage of H and S be null and void for failure to comply with the requisites of Article 52 of the Family Code. Article 53, Family Code. As legitimate children, they have the following rights. A. To bear the surnames of the father and the mother in conformity with the provisions of the Civil Code on surnames. B. To receive support from their parents, their ascendants, and in proper cases, their brothers and sisters, in conformity with the provisions of this code on support. And C. To be entitled to the legitime and other successional rights granted to them by the Civil Code. Article 174, Family Code. Marriage. Annulment. Grounds. The marriage can be annulled Because good faith is not a defense when the ground is based upon sexually transmissible disease on the part of either party. The marriage can still be annulled because the fact that both of them are afflicted with sexually transmissible diseases does not efface or nullify the ground. Marriage annulment. Judicial declaration. Spouse cannot validly contract a subsequent marriage without a court declaration of nullity of the first marriage. The law does not recognize the church declaration of nullity of a marriage. To enable spouse to get married lawfully to another man, she must obtain a judicial declaration of nullity of the prior marriage under Article 36 Family Code. Marriage annulment. Legal separation. Prescription of actions. Case: concealment of drug addiction existing at the time of marriage constitutes fraud under Art. 46 of the Family Code, which makes the marriage voidable under Article 45 of the Family Code. The action must, however, be brought within 5 years from the discovery thereof under Article 47(3). Family Code. Since the drug addiction of Bert was discovered by spouse in June 1989, the action had already prescribed in June of 1994. Although drug addiction is a ground for legal separation under Art. 55(5) and Art. 57 of the Family Code requires that the action must be brought within 5 years from the occurrence of the cause. Since Bert had been a drug addict from the time of the celebration of the marriage, the action for legal separation must have been brought not later than the 23rd of December 1993. Hence, spouse cannot, now, bring the action for legal separation. Marriage annulment. Proper party. The Family Code gives the right to annul the marriage only to an injured party. Article 47(5) Family Code. Marriage divorce decree. Void marriages. The marriage of Maris and Pedro is valid when celebrated because a divorce validly obtained by Johnson in Manila capacitated Maris to marry Pedro. The marriage of Maris and Pedro is still validly existing because the marriage has not been validly dissolved by the Maryland Divorce Art. 26 Family Code. C. The marriage of Maris and Vincent is void ab initio because it is a bigamous marriage contracted by Maris during the subsistence of her marriage with Pedro. Art 25 and 41 Family Code. The marriage of Maris and Vincent does not validly exist because Article 26 does not apply. Pedro was not a foreigner at the time of his marriage with Martz, and the divorce abroad in Maryland was initiated and obtained not by the alien spouse, but by the Filipino spouse. Hence, the Maryland divorce did not capacitate Martz to marry Vincent. D. At this point in time, Pedro is still the lawful husband of Maris because their valid marriage has not been dissolved by any valid cause. Art. 26. Family Code. Marriage divorce decrees. Filiation of children. The divorce is not valid. Philippine law does not provide for absolute divorce. Philippine courts cannot grant it. A marriage between two Filipinos cannot be dissolved by a divorce obtained abroad. Garcia v. Redu, Giarno. 138,322, October 2, 2001. Under Article 15 of the new Civil Code, laws relating to family rights and duties, status, and capacity of persons are binding upon citizens of the Philippines wherever they may be. Any marriage subsequently contracted during the lifetime of the first spouse shall be illegal and void, subject only to the exception in the cases of absence or where the prior marriage was dissolved or annulled. Nino v. Bayatag, Giarno. 133,778, March 14, 2000. The marriage of Sonny and Orin does not fall within the exception. Mere absence of the spouse does not give rise to a right of the present spouse to remarry. Article 41 of the Family Code provides for a valid bigamous marriage only where a spouse has been absent for 4 consecutive years before the second marriage and the present spouse had a well-founded belief that the absent spouse is already dead. Republic v. Nolasco Giarno. 94,053, March 17, 1993. Under Article 165 of the Family Code, children conceived and born outside a valid marriage are illegitimate, unless otherwise provided in this code. The legitime of each illegitimate child shall consist of 1/2 of the legitime of a legitimate child. Art. 176. Family Code. Marriage. Divorce decrees. Filipino spouses becoming alien. His case is not covered by Article 26 of the Family Code. For said article to be applicable, the spouse who filed for divorce must be a foreigner at the time of the marriage. Since both of them were Filipinos at the time of the marriage, the divorce obtained by Flor did not capacitate Virgilio to remarry. Art. 26 of the FC merely states the alien spouse without taking into consideration his or her nationality at the time of the marriage. While his case is not covered by the letter of Article 26 FC, it is, however, covered by the spirit of said article. The injustice to the Filipino spouse sought to be cured by said article is present in this case. Department of Justice Opinion No. 134 Series of 1993. Marriage. Divorce decrees. Filipino spouses becoming alien. Considering that Art. 26, second part, contemplates a divorce between a foreigner and a Filipino, who had such respective nationalities at the time of their marriage. The divorce in Europe will not capacitate the Filipino wife to remarry. The advice we can give her is either to file a petition for legal separation, on the grounds of sexual infidelity and of contracting a bigamous marriage abroad, or to file a petition to dissolve the conjugal partnership or absolute community of property as the case may be. Marriage. Donations by reason of marriage. Effective declaration of nullity. Father may not revoke the donation, because the child was not in bad faith, applying Art. 86, 3 of the Family Code. Marriage. Grounds. Declaration of nullity, annulment, legal separation, separation of property. Since AIDS is a serious and incurable sexually transmissible disease, the wife may file an action for annulment of the marriage on this ground whether such fact was concealed or not from the wife, provided that the disease was present at the time of the marriage. The marriage is voidable even though the husband was not aware that he had the disease at the time of marriage. If the wife refuses to come home for 3 months from the expiration of her contract, she is presumed to have abandoned the husband and he may file an action for judicial separation of property. If the refusal continues for more than 1 year from the expiration of her contract, the husband may file the action for legal separation under Art. 55(10) of the Family Code on the ground of abandonment of petitioner by respondent without justifiable cause for more than 1 year. The wife is deemed to have abandoned the husband when she leaves the conjugal dwelling without any intention of returning. Article 101, FC. The intention not to return cannot be presumed during the 30-year period of her contract. If the husband discovers after the marriage that his wife was a prostitute before they got married, he has no remedy. No misrepresentation or deceit as to character, health, rank, fortune or chastity shall constitute fraud as legal ground for an action for the annulment of marriage. Article 46 FC. The wife may file an action for legal separation. The husband's sexual infidelity is a ground for legal separation. 9 Article 55 FC. She may also file an action for judicial separation of property for failure of her husband to comply with his martial duty of fidelity. Article 135, 101, FC. The wife may file an action for legal separation on the ground of repeated physical violence on her person. Article 55, 1, FC. She may also file an action for judicial separation of property for failure of the husband to comply with his marital duty of mutual respect. Article 135, 4, Article 101, FC. She may also file an action for declaration of nullity of the marriage if the husband's behavior constitutes psychological incapacity existing at the time of the celebration of marriage. Marriage. Grounds. Nullity. Annulment. Legal separation. A. Declaration of nullity of marriage. 1. The drug addiction must amount to psychological incapacity to comply with the essential obligations of marriage. 2. It must be antecedent existing at the time of marriage, grave and incurable. 3. The case must be filed before August 1, 1998. Because if they got married before August 3, 1998, it must be filed before August 1, 1998. B. Annulment of the marriage contract. 1. The drug addiction must be concealed. 2. It must exist at the time of marriage. 3. There should be no cohabitation with full knowledge of the drug addiction. 4. The case is filed within 5 years from discovery. C. Legal separation. 1. There should be no condonation or consent to the drug addiction. 2. The action must be filed within 5 years from the occurrence of the cause. Drug addiction arises during the marriage and not at the time of marriage. Marriage. Legal separation. Declaration of nullity. In accordance with law, if drug addiction, habitual alcoholism, lesbianism or homosexuality should occur only during the marriage, they A. will not constitute as ground for declaration of nullity, Art. 36, Family Code. B. will constitute as grounds for legal separation, Art. 56, FC and C. will not constitute as grounds to render the marriage voidable, Art. 45 and 46, FC. Marriage. Legal separation. Grounds. Prescriptive period. Under Article 57 of the Family Code, the aggrieved spouse must file the action within 5 years from the occurrence of the cause. Marriage. Legal separation. Mutual guilt. An attempt by the wife against the life of the husband is one of the grounds enumerated by the Family Code for legal separation, and there is no need for criminal conviction for the ground to be invoked, Art. 55, Par. 9, Family Code. Mutual guilt is a ground for the dismissal of an action for legal separation, Art. 56, Par. 4, Family Code. The rule is anchored on a well-established principle that one must come to court with clean hands. The Philippine Constitution protects marriage as an inviolable social institution, Art. 15, Secretary 2, 1987 Constitution. An action for legal separation involves public interest, and no such decree should be issued if any legal obstacle thereto appears on record. This is in line with the policy that in case of doubt, the court shall uphold the validity and sanctity of marriage. Marriage. Property relations. Void marriages. Art. 40, Family Code, provides that the absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. The provisions of Art. 148 of the Family Code shall govern, Art. 148. In cases of cohabitation not falling under the preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. In the absence of proof to the contrary, their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply to joint deposits of money and evidences of credit. Marriage. Psychological incapacity. Psychological incapacity within the meaning of Art. 36 of the Family Code. In Santos v. California, 240-20, this particular ground for nullity of marriage was held to be limited only to the most serious cases of personality disorders, clearly demonstrative of utter sensitivity or inability to give meaning and significance to the marriage. Mere intention to live apart, working abroad, does not fall under Art. 36, FC. Furthermore, there is no proof that the alleged psychological incapacity existed at the time of the marriage. Psychological incapacity. In Santos v. California, Giarno. 112,019, January 4, 1995. The Supreme Court clearly explained that psychological incapacity must be characterized by A. Gravity, B. Juridical antecedents, and C. Incurability. Ferraris v. Ferraris, Giarno. 162,368, July 17, 2006. Choa v. Choa, Giarno. 143,376, November 26, 2002. The illness must be shown as downright incapacity or inability to perform one's marital obligations, not a mere refusal, neglect, difficulty or much less ill will. Moreover, as ruled in Republic v. Molina, Giarno. 108,763, February 13, 1997. It is essential that the husband is capable of meeting his marital responsibilities due to psychological and not physical illness. Antonio V. Reyes, Giarno. 155,800, March 10, 2006. Republic v. Quintero Jamono, Giarno. 149,498, May 20, 2004. Furthermore, the condition complained of did not exist at the time of the celebration of marriage. Marriage. Psychological incapacity. The existence and concealment of these conditions at the inception of marriage renders the marriage contract voidable. Art. 46, Family Code. They may serve as indiciation of psychological incapacity, depending on the degree and severity of the disorder. Santos v. California, Giarno. 112,019, January 4, 1995. Hence, if the condition of homosexuality, lesbianism or sexual perversion, existing at the inception of the marriage, is of such a degree as to prevent any form of sexual intimacy, any of them may qualify as a ground for psychological incapacity. The law provides that the husband and wife are obliged to live together, observe mutual love, respect and fidelity. Art. 68, Family Code. The mandate is actually the spontaneous, mutual affection between the spouses. In the natural order it is sexual intimacy which brings the spouses wholeness and oneness. Kai Ming Tsui v. California, Giarno. 119,190, January 16, 1997. Marriage. Requisites. Case 1. A. The fact that the parents of Isidro and of Irma did not give their consent to the marriage did not make the marriage void ab initio. The marriage is merely voidable under Art 45 of the FC. B. Absence of marriage license did not make the marriage void ab initio. Since the marriage was solemnized in articulo mortis, it was exempt from the license requirement under Art. 31 of the FC. 3. C. On the assumption that the assistant pilot was acting for and in behalf of the airplane chief who was under disability, and by reason of the extraordinary and exceptional circumstances of the case, that is, hostage situation, the marriage was solemnized by an authorized officer under Art. 7, 3, and Art. 31 of the FC. D. Failure of the solemnizing officer to file the affidavit of marriage did not affect the validity of the marriage. It is merely an irregularity which may subject the solemnizing officer to sanctions. Marriage. Requisites. Case A. The marriage is voidable. The consent of the parties to the marriage was defective. Being below 21 years old, the consent of the parties is not full without the consent of their parents.